Thank you.
Good afternoon, my lords. Due to the overlap between the two appeals, the approach that I propose to take is to deal with it in three sections. So I intend to start with a general submission on what we see as the general principle that is common to both of these cases, and that's the extent to which the Secretary of State is required to consider the issue of impact, and related to that, the nature of the discretion that arises and the scope of that discretion. And I intend to do that by taking you in particular first to parts of the guidance, just to explain the nature of the scheme, and then to the key authorities as we see them. Then the second part of my submissions will be the specific submissions on Prestwick's case in response to Mr. Sully, and then thirdly, submissions in our appeal in supporting Care. I think they will probably be pretty short because they'll mostly be covered by the first section. I'm not going to address the cross appeal in supporting Care. Once Mr. Malik's addressed that, Mr. Hill will cover that tomorrow.
Yes.
It occurred to me over lunch that because of the fact that this first part relates to both appeals, you've heard quite a lot about Prestwick and the background. So before I start with my general submissions, I just wanted to highlight the particular paragraph in supporting Care that we criticise, that we say is at the crux of that appeal. And that is paragraph 55, which is, so it's your third volume of authorities, page 1147.
We've got it in the trial bundle, in the appeal bundle.
You also have it in the core bundle, yes.
Which we've been, oh, so we've been marking up. So.
My apologies, Mike.
Thank you very much.
Which paragraph, Mr.
Volume 3, 1147.
Paragraph
55. So this is the final part of it. So having upheld the Secretary of State submissions on grounds 1 to 3, and found in favour of the claimant on ground 4, the critical point that the judge makes is at 55. So it says the content of the decision letter indicates that the principal, if not the only reason why the licence was rejected, was because the policy said revocation was mandatory in the circumstances. There was no actual, or at least demonstrable, engagement with any other consideration, such as impact upon the other 67 workers and their families, the vulnerable individuals under care, or the adverse impact to the claimant and the wider industry. Similarly, no engagement with the question of whether revocation in such circumstances is reasonable and proportionate when a finding in relation to dishonesty related only to the role of a single employee from a workforce of 162. Etc. In those circumstances, I find that on the balance of probabilities, the claimant has demonstrated that the Secretary of State failed to conduct an adequately reasoned global assessment of all relevant considerations in deciding whether to revoke or downgrade the sponsor licence. So the essence of that reasoning is that the Secretary of State didn't conduct a global assessment of all of those factors, so impact on workers, impact on the industry, etc., and make the general proportionality assessment before deciding whether to revoke in a case where it was, in fact, 2 mandatory grounds for revocation. And the Secretary of State's case is that sort of consideration that the judge indicates that paragraph 55 is not required. So that's the essential difference between Mr. Malik and myself in the supporting Care appeal.
Not required or not permitted? In other words, I don't want to anticipate what you're going to say later, but it may help you to know that one of the things that we are interested in, your help on, is, remember that passage we were shown in, I forget the Deputy Judge's name now, where he said that it's not a two-way street. And I understand his passage to be saying that even when you have a mandatory ground for revocation, If the Secretary of State chooses to exercise a discretion residually not to revoke, that would not be unlawful. And do you say that that's a correct way of looking at it?
Both yes and no, my lord.
Right.
We accept, and this is obviously at the heart of this, we accept that there is a residual discretion.
Yes.
There must be as a matter of public law.
Yeah.
But that discretion is a residual discretion. So I don't think I would accept that it would be open to the Secretary of State in a particular case to decide, well, there's going to be a lot of impact in this case on the people who work for you and on the community. And it doesn't seem proportionate, because that's not what the guidance says. It may be that no one would criticise that decision, of course, because the sponsor isn't going to complain about it. But the guidance, as I'll come on to, is very clear that there are the three categories. There is the we will revoke, we will normally revoke, but there may be exceptional circumstances, and we might revoke, but it depends.
Right.
If the Secretary of State were to take an approach that was contrary to the guidance, I would have to accept that would likely be unlawful, because the Secretary of State, there's a legitimate expectation that the Secretary of State will follow their own guidance. And my Lord will no doubt come on to it, but my reading of that passage by the Deputy Judge is that the reason that he considered it's not a two-way street is that this isn't a free-for-all in terms of a discretion when it comes to a mandatory ground, but it's an acknowledgement of the existence of a residual discretion which may arise in a particular case for a particular reason.
Right. Okay.
Well, so that, in a nutshell, that's supporting care. So the difference between the two cases, as I see it, is that in Prestwick it's put in terms of fairness. So it presupposes that it's a relevant consideration in the broader sense, the impact, and therefore you needed to give us the opportunity to make those submissions, and then the inevitable consequence, you needed to actively consider those once we made them to you. In supporting care, it's effectively a rationality challenge. I think the judge puts it in terms of reasons, because you haven't explained that you've done this, and therefore the lack of reasons, I think it's implicit in that paragraph, suggests it's irrational or possibly disproportionate.
I'm not sure it is just that. I mean, line 4 of paragraph 55, there was no actual or at least demonstrable engagement with any other consideration, such as the impact of revocation. I may be wrong, but the way I read that was that there was a failure to take account of a relevant consideration.
Yes, which would not be would that not be a rationality
I don't think so. No.
challenge, failure to take into account relevant considerations?
No. That's classic failure to take it. That's an error of law. If it's a matter of, if you don't take into account a consideration which you are required to take into account, that's an error of law. That's not a question of your decision being irrational.
Sorry, my lord, I don't disagree at all. Sorry, I was taking into account relevant considerations under the umbrella of rationality.
Yes.
As opposed to unfairness, which is a different type of challenge.
Yeah. Well, one of the problems with public law is that there are different labels which people use. And actually it's a problem which goes all the way back to Wednesbury.
Yes.
When Lord Green also used, and many people think confuse two different categories of error. But anyway, let's see if we can adopt my categorization. Yes. I hope it's helpful analytically. My first category is error of law.
Yes.
Where, for example, you err in law because you misdirect yourself, or you fail to take into account a relevant consideration, you take into account irrelevant. So you decide a case because somebody had red hair. That's the classic example. That's just an error of law. Secondly, even though you have taken into account all relevant considerations and have not taken into account irrelevant considerations, the substance of your decision is attacked. That's rationality. It said that no reasonable decision maker could have reached that decision. And thirdly, procedural unfairness, where it said that in reaching your decision, you acted in a way which is unfair procedurally. So you're not attacking the substance of the decision, but you're saying the procedure was not fair.
Yes.
And those are three, broadly speaking, I think, those are the arguments that we're grappling with in this case, or these two cases as well.
Well, that's very helpful. In that case, I would agree entirely that this comes under the first of those.
Yeah.
So if that's helpful, just to have in mind the key issue in supporting care, and then I'll come to the submissions. I'll start, if I may, with the guidance, but I'll try to do it as quickly as possible.
Yes.
There are 4 parts to the guidance, of which 3 are particularly relevant to these appeals. The first one covers the application for a licence. Second deals with how to sponsor a worker, and the third, which is most at issue, are the duties and compliance for sponsors. And in my submission, together, the 4 parts of those guidance, the fourth one relates specifically to skilled workers. But the 4 parts of the guidance create a scheme.
You said 4, it's compliance 4.
There are 4.
So it's duties and compliance, right?
Duties and compliance is 3. 4, it relates to skilled workers, but it's not been at issue in this case.
Thank you.
But together, those 4 parts of the guidance constitute a scheme, and an organisation or a business, if it wishes, can apply under that scheme to be a sponsor. If it does so, as we know from Lord Sumption, its participation is governed by the scheme. As he put it, if you choose to take part, you abide by its rules. And the scheme covers all aspects of the operation of the scheme. It covers eligibility, it covers the terms on which a sponsor holds a licence, but it also sets out, in particular in Part 3, the process that the Secretary of State will adopt and the sanction for breaches of the guidance. The other general point about the guidance is that, this is in Part L1, I'm not going to take you to it, but it's page 12 of the supplemental bundle in PCL and 52 in supporting care. I should say you have 2 separate parts of guidance. You have 1 in each case because it changed. It's a later version in supporting care, but there is no material difference that I've been able to see in any of the sections that we are looking at. So some of the numbering has changed, but in terms of the wording, there isn't anything that I can see that's changed. But section L1 makes clear that what a licence does is enable a business to employ a person that doesn't otherwise have immigration permission to work.
Want us to have this in front of us, do you think? Would be helpful to have?
I didn't think it was necessary, my Lord. If it would be, I will be taking you to the guidance, so it may be helpful to have supplemental bundle in Prestwick open. Yeah. Take it from there. This is at page 12. I've taken that from L1.1. So what it does is enable a business to employ someone who wouldn't otherwise have immigration permission. It's not a requirement for any particular business, including a care home, to operate. It's got nothing to do with their registration or anything of that sort. And all businesses remain, including care homes, remain free to employ anyone who does have immigration permission. So that will obviously include British nationals, but it also includes people other set out at L1.2, so people with settled status, people with indefinite leave to remain, and so on. So what it does, in effect, is to give the licence holder access to an additional pool of workers that other people in that sector who are not sponsors will not have access to. There are financial and competition advantages that obviously accrue to businesses in that sense. In terms of the financial advantages, they're set out, for example, in the evidence from Mr. Malhotra in Prestwick. He talks about having to pay above market rates to try and recruit enough people if they don't have access to this, etc. So that's what the guidance, that's what the sponsorship is for in terms of those who apply to be sponsors. Then the guiding principles of sponsorship, and this is page 15. I was going to take you to this. This is in part 1, and you've probably seen this in some of the case law. There are 2 main principles. First, that sponsorship is a privilege, not a right. And it goes on to say that those who benefit most directly from employing migrant workers have to play their part in the various things set out there. And secondly, and particularly important in this appeal, that when a sponsor is granted a licence, significant trust is placed in them. With the trust comes a direct responsibility to act in accordance with the UK's immigration laws. What I would emphasise is all parts of this sponsor guidance and with wider UK law as well. And then it warns them, this is right at the beginning of the first part of the guidance, we will take compliance if you don't do so.
So whereabouts is that?
That's L2.3. And there's an identical version at page 155 in supporting care. Part 1 then, this part of the guidance covers the process of applying for a licence. I wasn't going to go into any detail about that, save to say that there are, at annexes L1 to L4, the circumstances in which an application will be refused. And they have the same structure that we see in part 3. So L1, which is at page 39, circumstances in which we will refuse your application to be a sponsor. L2, page 42, circumstances in which we will normally refuse your application. And L3, circumstances in which we may refuse your application. L4 is a different type of annex. It just lists certain convictions that have particular consequences. But this calls back to the observation, again in the New London case by Lord Sampson, that in terms of looking at rules and whether things are mandatory, it's exactly the same in terms of whether you're applying for the licence or whether your licence is being revoked. The wording, we will revoke, we will normally revoke, is the same in both sections of the guidance. So then I turn to the critical part of the guidance for our purposes, which is part 3, which begins at page 46. And after the contents, one of the first things to highlight, which is page 51, one of the very first things that the guidance says after the about the guidance section is to make sure you meet all of the relevant requirements, fulfil your sponsorship duties, you must read the following parts of the sponsor guidance in addition to this document. So they must read this document, they must read part 1, and they must read part 2. There's a requirement to familiarise themselves with the guidance. It's not just implicit, but it's there in terms. One of the things that part 3 does is that it sets out the process to be followed by the Secretary of State and the sponsor when there is an inspection and when there are concerns. And that's at page 68 and onwards. Heading at 66, compliance checks, and then at 68, what happens during a compliance check. And the submission is that this part of the guidance sets out what will happen, and the Secretary of State would accept that creates a legitimate expectation on behalf of the sponsor that this process will be followed, absent some good reason for it not to be followed. But the process that is set out there is very clear, that you have the inspection. Inspection may include interviews, But then the guidance goes on to say what happens in terms of the suspension letter and the then decision as to revocation, which I'll come on to in a moment. But just before I do, I wanted to make a point about the nature of the inspection. One of the points that was made by Mr. Southey this morning is he said, I'm not sure if it was a concession as such, but he appeared to accept that in Annex 1, in Part 3, there are certain of the grounds for revocation where he said something like you couldn't complain, or something, the bad faith, dishonesty, that sort of thing. But he said, well, others, they're less serious, they're less important. And with respect, that's not a good argument, because it's for the Secretary of State to decide what is sufficiently important, subject, of course, to rationality and so on. There's no challenge in this case to the rationality of the guidance. And in fact, there are very good reasons why things which may appear more innocuous are in the mandatory grounds for revocation. And one of those is the nature of the compliance system. So inspections will happen from time to time. They may not happen at all. They may not happen for years. But there may be an inspection, maybe announced, maybe unannounced. When the inspection is carried out, the compliance check will follow this process. So Home Office officials will interview a number of staff. So in supporting care, they interviewed 6 members of staff. In Prestwick, they interviewed 29. The Secretary of State does not have the ability or the capacity to comprehensively assess every employee employed under a sponsor licence. It relies on compliance checks to see that things are being done properly. So where, in a case like supporting care, there are 6 employees who are interviewed and one of them is not working in accordance with a job specification, it is not sort of unserious in the way that I think it's suggested at one point in the story. It's 1 person out of 150 or whatever it might be. It is a mechanism by which the Secretary of State can ensure that there is a system of compliance, because those who sign up to this guidance know that if they get this wrong and there's a compliance check, the consequences in the annexes will follow. And that's a legitimate approach the Secretary of State to take. And I don't accept that it's open to Prestwick or some to say, well, some parts of Annex 1 are more mandatory than others. The Secretary of State is either entitled to have mandatory grounds for revocation or she's not. But if she is, subject to it being reasonable, it's up to her judgment as to what needs to go into Annex 1, Annex 2, Annex 3. The guidance goes on, page 69, the outcome of compliance checks, and it sets out, and you've probably seen this, where effectively the breach is relatively minor, it can be downgraded, they can give them the opportunity. Otherwise, if it's more serious, they may decide to either suspend or, in some cases, revoke immediately. If they suspend, which has happened, it happened in both of these cases, that's dealt with at page 76 onwards. And the process, importantly, especially in Prestwick, the process that they're entitled to is set out at 76. At the bottom of the page.
Can I just interrupt you there?
Yes.
What does suspend actually mean in the real world? Does it mean that you... Well, what does it mean? What's the legal consequence, if any, of suspension?
The suspension, I think in practice, and as Mr. Southey said, is that they can continue to employ the employees that they have. So if they've provided a certain number of certificates of sponsorship, brought over a number of overseas workers, while the licence is suspended, they can continue to employ those workers.
That doesn't sound like suspension to me. That just sounds like nothing's happened.
Well, they can't recruit any further.
Suspending the power to recruit.
Suspends power to recruit.
Right.
But they're not. Those workers can continue during the period of the suspension.
I see.
But
And the worker's position is not affected at all
no,
until revocation.
until revocation. At which point, I think, and this wasn't. I don't think it was a point mentioned this morning. At which point there is a certain period of time.
It's in the schedule, or there is a table we were showing.
That the workers have to see if they can get employment elsewhere. So although a certificate of sponsorship is specific to an individual, if organisation is no longer trading, they can see if there's another care home, for example, where they could work and you can transfer the certificate of sponsorship.
Do we know how many organisations have licences in this country? I mean, are there lots of agencies like Prestwick and Supporting Care to whom these employees, these workers could be transferred, or are they like snow leopards?
Well, I'm sure we can. I have a feeling it's in fact published online, so I'm sure we could give you that information tomorrow.
You're being prompted.
Is that the number of sponsors? There are 115,000 sponsors.
Say that again?
115,000 sponsors. Yeah.
115,000 sponsors.
That's across a variety of sectors, but
Yes.
yeah.
Okay.
Under this
Is this right, that the worker concerned could, in principle, seek employment with any of those, so it wouldn't have to be in the same sector as previously? But it would have to be with one of those sponsors rather than, for example, for another employer in this country who is not a sponsor.
Yes. Yeah, because you have to have the sponsorship to be able to sponsor them. And the other thing is that each sponsor, I'll be corrected if I'm wrong, but each sponsor applies for a certain number of certificates of sponsorship. So they'd have to find someone who has a space in their allocation, which might be because sometimes a recruited worker doesn't turn up, sometimes they leave, but they can't just create, without applying, another space.
How many are there in the care sector?
There are, my lord, 11,000 care sponsors. I'm very grateful.
11,000.
11,000.
That's in England. Is that UK wide or England Wales?
That will be UK wide. Yeah, UK wide.
Thank you. That's very helpful. Yep. Since we've interrupted you, Mr. Magwell, can I just try and, I've been, for my own benefit, I've been trying to put where this all fits in to the legal context. Everyone has quite understandably taken us straight to the guidance, but public law is usually concerned with legal powers, and powers usually have their source in legislation. So what legislative power are we actually talking about here when a license is revoked?
Well, that's a very good question. I believe, and I'm grateful for any correction from Mr. Sully.
You may want to come back to this, because one of the reasons I ask you this is that the law on relevant considerations essentially says, as I understand it, that whether something is a mandatory relevant consideration or not turns upon the true construction of the legislation which confers the discretion in question. And so it may be thought to be important to see what the legislative power is. May also have a bearing on a question that is sort of lurking in the background to this case, which you've touched on in your introduction, which is what is the nature and scope of any residual discretion?
Yes. My Lord, in the Supreme Court, I think the answer is given that it doesn't stem from a legislative power, but perhaps Mr. Sully.
I was going to suggest that the basis of this, and Melanie Frink can correct me, is that Section 1 of the Immigration Act it gives essentially Secretary of State powers to control immigration. Section 3.2, which has been touched on indirectly because it was considered, for example, by Lord Sumption. I mentioned it, and you had mentioned it this morning, and mentioned it when addressing the issue, the New London Care. I think it was Lord Sumption's judgment in relation to that. Section 3.2 requires the Secretary of State to have immigration rules governing the practice adopted in relation to admission of people into the United Kingdom.
Yes.
The immigration rules in question, we can provide those for you if need be, require that the relevant workers have certificates of sponsorship. So that practice essentially has, to the extent that your immigration rules have parliamentary authority, that my lord will be very familiar with the fact the immigration rules are an odd hybrid. And then the particular approach to certificate of sponsorship, and this is what Lord Sumption was ultimately upholding, and that's why in one sense that his judgment may be important. The particular approach to certificates of sponsorship is all in guidance. So that's in one sense, the legislative background, if I can put it that way, to certificates of sponsorship. It's from primarily Section 3 of the Immigration Act through the immigration rules into a concept within the immigration rules, which is then purely governed by guidance. I don't know whether my learned friend...
Yeah, I mean, my lord, I think the section that I was going to take you to is page 737 in volume 2, which is in the New London College of History and Court, paragraph 28.
Sorry, just bear with me. Volume 2. Page
737.
Yes, thank you.
And in dealing with this point, that those first sentences in paragraph 28, I wondered about the answer to this question as well. My reading of this is that Lord Sumption is saying that the creation of the scheme is something that is done under the Crown's general administrative powers to carry on the ordinary business of government, rather than under any specific legislation. And I say that in particular because he ends that section by saying, next to letter D at page 738, without specific statutory authority, Secretary of State cannot adopt measures which are coercive, etc., but these measures aren't because it's a voluntary scheme. So I think he is proceeding on the basis that there is no specific legislative basis for it. But Mr. Southey is right that the certificates of sponsorship that enable an individual to come to the country under the scheme, which have their place in the immigration rules, must flow from the Immigration Act. But the scheme itself, as I understand it, is created under the general Crown's power.
Yes. Well, we don't want to stray into things that we don't need to decide. As Lord Sumption says, the extent of these powers and their exact juridical basis are controversial. And I don't think we need to resolve those controversies for the purpose of these two appeals. But what I think we may need to grapple with is what are mandatory relevant considerations.
Yes.
Because if we don't have here the benefit of a statutory framework, which is usually how you decide on their true construction and what the relevant considerations have to be, then the question arises, well, what is going to tell us where the relevant considerations are located? And is it your submission that where they are located is in the guidance?
Yes. It's akin to the rules of a club or similar.
I'm sorry?
The rules of a club, an unincorporated association or something of that sort. You find the rules within the rules that define it. So I was just coming on to the process, which begins at page 76. So where they think there's enough evidence to suspend, we write to you giving reasons for the suspension, so that there is an entitlement to know why you've been suspended.
I'm so sorry, Mr. Mackle. Which page are you on now?
76 of the supplemental bundle in Prestwick.
Prestwick supplement.
It's at the bottom of the page, my lord.
Yes. Thank you. Process.
And then 9.11, you have 20 working days, so 4 weeks from the date of the written notification to respond to our letter. And as Mr. Southey said this morning, I do rely on this paragraph in the Prestwick case because the guidance, and as I've said, the sponsors are required to be familiar with this guidance. The guidance says this is your opportunity to seek a review of our decision and to set out any mitigating arguments you believe exist. Your response to us must be in writing and set out with relevant supporting evidence which grounds you believe to be incorrect and why. We may give you more time if you need it, but it does say we will not hold an oral hearing, so there is a specific...
You're going to come on to, are you, what is meant by mitigating?
Lord, I was going to deal with it now. We say it means what it says. It's both, it's in the normal sense that that's understood. Anything you want to say by way of mitigation, whether that's mitigating in the narrow sense, the specific feature, so this happened because of this, or, well, you shouldn't revoke my license because of this broader issue. There's no magic to that, and whether one looks at it objectively or subjectively, as it was put, it is clear in my submission on the face of that any mitigating arguments you believe exist, it's as broad as it needs to be.
But if someone chose to say that, yes, there was a breach, yes, there was a mandatory breach, but here is my evidence about the devastating impact it will have on not just the company, not just its employees, but on the wider public, including the residents in the care home, the local authority in its area. If they, I know one of your complaints is they didn't put that before you at the time, but suppose in another case they did put that before you at the relevant time, taking advantage of this paragraph. Would you put that in the bin on the basis that it's not relevant?
It wouldn't be put in the bin, one would hope, my lord, but it's unlikely to make any difference on a mandatory ground because I'll come on to how some of the cases put it, which I would adopt. In effect, the exercise of that residual discretion is going to be in respect to something that's not envisaged by this guidance, because the guidance takes account of the fact of the things that are going to be there in almost every case. So it will have a big impact on those who are employed. It will have a big impact on whatever service that business provides. If it's care, it'll have some impact on care. It's not for me to say on behalf of my clients it will never, because they do accept that there's a residual discretion. But I have asked them for an example, and they're not able to give me an example, but they say, well, if effectively we would know it if we saw it. But in terms of mandatory guidance, the mandatory breaches, the position is you should expect to have your licence revoked, even if you say, yes, we accept it.
I'm sorry to press you on this. Let me not use such provocative language. Would they take it into account, or would they refuse to take it into account on the basis that it's irrelevant? I mean, you can take something into account and still come to the same decision. That's a different point. But what I'm asking you is, would they actually say, I'm not going to take this into account because it's irrelevant? Or would they say, I am going to take it into account, but given that this is a mandatory ground for revocation, I'm still coming to that decision?
If it was, my instructions are, if it was something such as the care home will have to close, there'll be a big impact on care sector. That they would take it into account only in the sense that they would see, oh, well, it's that representation.
Yes.
But they wouldn't actively think, well, do we need to not revoke in this case because it's a big care home? As I understand it, the position they would take is, well, no, that is not the sort of, we deal with that in the way that Mr. McGee says, in that we liaise with the Department for Health and Social Care to see if we can make sure that provision continues elsewhere or whatever it might be. But it is not, my lord puts it in a very black and white way, is it relevant or is it not?
Yeah. Well, I'm sorry, but that's the basis of the decisions that are under appeal. One has said it's not relevant as a matter of law, and we've got to say whether that's right or wrong.
It's not capable of, that sort of submission is not capable of overturning a mandatory ground for revocation.
Yeah.
So what is the point of including, of saying it will be a accommodated within mitigation.
I mean, save that there might be something that's unforeseen
Well,
in that submission.
I was going to put an
There is
extreme
no-
example too,
Yes.
of a underpopulated, under-resourced part of the country in a pandemic. Some very extreme situation.
Well,
Maybe would it affect your approach to the breach, or is there something else that it would affect? You mentioned the steps you would take to contact local authority, the DHSC and local authorities. Is there something else that would follow on from this factor having been identified in this way?
The fact of it being a small town, that sort of thing, is not relevant in the sense that my lords have put to me, in the sense that it is not going to affect the outcome. Something like it happening in the pandemic might be an example of the case where the residual public law discretion to act outside your guidance and contrary to your own guidance would come into play. I mean, the pandemic, indeed, a number of cases before this court, public authorities acting in ways in which they would never have otherwise acted. So that may be the sort of case. But the fact that it's a small town and a large care home, no, it would.
I've unhelpfully put 2 points to you then. Yep. The second point was you were saying that it might have, I think you said, it might affect what you did next in terms of contacting DHSC and local authorities. Would that be the sort of thing that might follow?
Yes.
Efforts to assist the workers involved seeking to find an alternative sponsor or something like that.
Well, Lord, yes, and I was going to come on to that, but for your reference, it's at 251, 252 of the Prestwick bundle, supplemental bundle. It's the statement of Mr. McGee, and he says that since 2022, there has been a process by which, if there is revocation of a licence, then the Home Office works with local authorities, with DHSC, to try to facilitate continuity of care.
See, I don't want to put words in your mouth, but what I thought was happening here, but please correct me if I've misunderstood, is that the Secretary of State is prepared to and does take these matters into account. So that they're not prohibited from consideration, but that they're not something that you would say are mandatory relevant considerations. In other words, I mean, there is in public law, as I understand it, there's a third category, which is the middle category, which is permitted considerations. So it's not unlawful to take them into account, but it's very much a matter for your judgment whether and to what extent you wish to take them into account, subject always to irrationality. And I thought that's what really the Deputy Judge was getting at, that you wouldn't be acting unlawfully if you took them into account, but you're not required to take them into account or actively to request submissions about them. But if somebody puts them in front of you, and it might not be the appellant, it might be a local authority. So has Mr. Norman had just written to you. I'm not sure, correct me if I'm wrong, you may be saying we will simply ignore it. If Mr. Norman writes to us, we will ignore him. Or, and I thought this is what actually is going on, as per paragraph 35, that if somebody draws this to our attention, we will take it into account. But the consequence may well be, because it's a mandatory ground of revocation, it's not actually going to lead to no revocation. It might lead to some other consequence. It might be mitigation. It might be that we look for help from the DHSC. Am I missing something?
No, my lord. I think what's thrown me is my efforts to answer your question of whether it's a relevant or irrelevant consideration, because that is a very difficult. I'm finding that a very difficult dichotomy. If perhaps I answer the question more straightforwardly, in this case, for example, if Mr. Norman's email had come before the decision was taken, it would, of course, have been looked at by the decision maker. The decision maker would have looked at it, and as Mr. McGee indicates, he said, well, this is the sort of thing that we know about. this is a mandatory breach. It's too serious in the case of a mandatory breach for us to allow you to continue being a sponsor regardless of these things.
Yes.
So it's not going to affect the decision. So, my Lord, I'm afraid I don't know whether you would say that's a relevant or an irrelevant consideration.
Well, but you may want to reflect, and it may be overnight that everyone wants to reflect on. I'm not saying anything new. I mean, public law has said for at least 30 years, ever since cases like viewings. I think more recently the Supreme Court gave a judgment approving viewings in Friends of the Earth in 2020. There's in fact a threefold classification. There are prohibited considerations, in other words, things which it is unlawful to take into account. Classic example, the teacher has red hair, so we're going to sack her. As long ago as Short and Poole Corporation, sorry, more entities outside. As long ago as 1926, this court held, in short, that if you sack a teacher for having red hair, that's unlawful. Because that's simply irrelevant. You cannot take that into account. At the other end of the spectrum are mandatory relevant considerations, which, as a matter of law, you must take into account. And if you don't, that will vitiate the decision. But as I understand it, there's a middle category in the middle, which are permitted considerations. So that you're not acting unlawfully if you take them into account. They're not irrelevant in the sense of being prohibited, but they're not ones that you are required as a matter of law to take into account. You may choose to, and whether you have acted lawfully or not will then depend on whether you've acted rationally. The classic Wednesbury rationality test applies. And I don't know if that is helpful or unhelpful, but that may help us to navigate through this apparent conundrum, which the two decisions under appeal seem to have arrived at. Is the one seems to say you've got to take it into account, another one says you can't take it into account.
Well, I will give that some thought.
Right.
The difficulty that I have with it is that in that permitted considerations category,
Yeah.
it will cover things where it's not a rule in the sense that we've heard it, where if it's a permitted consideration, someone makes representations about it, the Secretary of State needs to think about that quite carefully, and needs to give reasons, and needs to perhaps listen to further representations. There's a whole range of things.
Yes.
But equally, in a case where something is a rule, the Secretary of State may need to consider it in the sense, well, I've received it, I've looked at it, I've seen the nature of the submission, but I don't need to address this in the decision because the rule is very clear.
Yeah. Well,
I'm not sure
I'm not sure that analysis would necessarily be inconsistent with, for example, Friends of the Earth. And you might just want to have a look at, I think it's Lord Sales and Lord Hodge gave the joint judgment in Friends of the Earth. I think they deal with that scenario from memory. I think that they envisage a situation where you don't say anything about something. And they say that's not necessarily unlawful because you're not required to take it into account. But the important point that I'm really inviting you to help us with is it something that you can take into account if you wish to? Because then it's not a prohibited consideration, but it's very much a matter for your judgment, subject to rationality, about whether you take it into account. That may have an impact on Tameside, you see, because the Tameside argument against you is that you didn't do enough to make inquiries. And you made, I don't know, you'll come back to this when you address Ground 2. Your submission may simply be, well, actually, we did. We had some information from DHSC. We were aware of all the relevant matters. We didn't feel that it was necessary to do any more.
Yes. Well, I will come back to you if I may on that. If perhaps in the meantime, if I come back to the sequence. So I've focused on the guidance and the process that someone is entitled to, and I've emphasised 9.11 in terms of what it says and what the sponsor should be taken to know about what happens. And then the only other thing I was going to say about the guidance is it's the part on revoking your guidance begins at 79, and the section how we decide whether to revoke your guidance, and it sets out the difference between the categories, as I mentioned. So C1, these are mandatory grounds. We will revoke your licence, and if they arise, we may revoke your licence immediately, rather than going through the suspension. C2 is we will normally revoke unless there are exceptional circumstances. I just emphasise that a little bit because in supporting care, the judge appeared to regard Annex C1 as being like Annex C2, so there may be exceptional circumstances, but that's Annex 2. So and then you have the lists of circumstances set out in the three annexes. They do change from time to time. There were slight changes, alterations and additions in the various annexes between the two versions, for example, but none that are relevant in these cases, but they are reviewed from time to time. Just in terms of the consequences of revocation then, and it's page 81 and 82, there is a process for reapplication once the 12-month cooling off period has expired. The point I emphasise at 10.18 is that someone who is subject to a ban and then reapplies, they are treated in the same way as anybody else when they reapply. It does say that if you will be required to demonstrate you've addressed the reasons why your licence was previously revoked, but there isn't any other consequence in terms of preventing people from reapplying or subjecting them to any additional hurdles.
Where do we see in the guidance any express reference to what can, the transfer of workers to other licensed sponsors? In C10.10, for example, or somewhere else. On page.
C10.10 deals with
how revocation affects your sponsored workers.
Yes, so that shortens their permission. Well, could I come back to you on that? I think it's somewhere else in the guidance, and it may be that I can find the.
Yeah, yes. I mean, this is what I've been looking. I, for my part, would be interested to know whether there is any discretion within the secretary has a discretion to take measures to assist workers in the circumstances which arise. We'll come back to that if you would.
The Secretary of State does have such a discretion, and that's the process that Mr. McGee describes.
Yes, I haven't tracked that if that's in the guidance.
In the guidance.
At some point. Thank you.
Thank you, my Lord.
No, Mr. Becknell, I'm sorry, we've interrupted the flow of your submissions. So if you'd like to go back to the structure of your submissions and make them as you see fit.
Well, I'm in the court's hands. I'm conscious of the time, but I will keep this as short as I can. The only other point I wanted to make about the structure of the guidance is that other than revocation itself, which is that the consequence of which is you're no longer part of this scheme. You can't recruit workers from overseas, and after the period has expired, you have to let go the sponsored workers that you have. But there are no other consequences. There is no financial penalty. There's no criminal sanction. It's simply you're not in the scheme anymore. So then the next topic I was going to deal with is in terms of the case law. So how the courts have dealt with these, the process requirements in particular for the guidance. In my submission, the most important of these is the St Andrews College case. That's the decision of this court, and these issues have come before this court 3 times. It's the most recent of the 3. That is at page 4, it's the beginning of volume 2.
What page?
478.
Starts at 469.
Oh, yes.
Starts at 469.
Thank you very much. Is it paragraph 29?
Yes.
Thank you.
And just to note, this is a judgment by Lord Justice Haddon Cave,
Yes.
who, as Mr. Justice Haddon Cave, given the judgment at first instance in Raj and Knoll, which was upheld by the court. He then comes back to the issue in this case, in this court, and effectively approves what he said at first instance in Raj and Knoll and adds to it. But the paragraph 29, I'm not going to go through. These are the principles summarised in our skeleton argument.
Yes.
I think it's 24 to 25. Just to note, the formatting in this judgment is slightly erratic, and for the 11th and 12th principles, one has to go to page 481, because there are the 8 principles from Raj and Knoll, and then he adds 4 additional principles, which he takes from a case called Westec, which you have in the bundle, but I don't need to go to. But at 35 and 36, at page 483, he makes some additional points that I thought I should emphasise.
Yes.
The first of those is that he says, I should emphasise the watchword for the sponsorship system is trust. The efficacy of the system depends fundamentally on trust. This is often overlooked or ignored by claimants seeking to challenge the suspension or revocation. Secretary of State must be able to trust those that have been given sponsorship status. That's because they have the power to assign a certificate of sponsorship, which allows people to obtain visas. However, with power comes responsibility, and then it talks about some of those key responsibilities. The second point is 36. It says that under this system, the discretion accorded to the Secretary of State to suspend or revoke is very broad. This is necessarily so because the system depends on the Secretary of State trusting those. And in my submission, he's talking there both about the process that the Secretary of State chooses to adopt as well as the outcome. And then 2 further points from that case at the end, page 490. And the first of those is at paragraph 65, and this was a point that was raised by this court in Raj and Knoll, but left undecided. They said we don't need to decide in that case whether simple suspicion of a breach is enough. But he decides, and it's part of this decision, that in fact there does not have to have been a breach. There just has to be reasonable public law compliant grounds for suspecting either that there is a risk that the sponsor might not be complying or a risk of a breach of immigration control might occur. So as long as he puts it at 66, there's reasonable articulated, unallayed concerns that they can't be trusted, then that's enough. And then finally, at 69, he adopts an observation from Mrs. Justice McGowan in another case, that the grant of a sponsor status is a fragile gift. Constant vigilance about compliance is a minimum standard for such sponsors. The burden of playing an active role is a heavy one, and the Secretary of State is entitled to review purported compliance with a cynical level of supervision. And my Lord, again, I would make the submission that that is not only talking about the outcome, but it is also talking about the procedure, and the reference in the 12 principles to the light trigger is similarly the procedural question. So a cynical level of supervision is what's referred to. I'll come back to that. What I would say is that the language of this judgment, of particularly those 12 principles, the observations at 35, 36, and the observations on the last page, are not compatible with the suggestion, the supporting care argument from the judge in that case, that what the Secretary of State needs to do, faced with concerns, is to then step back, consider the impact on workers, consider the impact on a whole variety of things, and make a globalised and proportionate assessment that presumably can be tested in the court. Rather, this is a light trigger, a cynical level of supervision, etc. The next case that I was going to mention in this court is the new London College case, so before it went to the Supreme Court. You have that in volume 2, and it's at page 722 that the relevant section the judgment begins at 690.
That's the page number.
722. I'm not going to read that paragraph, but
Could you give me the paragraph number? 'Cause
97.
Right, I have the wrong page number. I'm sorry.
722.
Yeah, mine's different.
Oh,
Yeah, paragraph 92.
97.
97. Yeah, let me just get that.
Internal page.
Oh yes, I have it now.
5.
Yeah, thank you
I mean, look, this is the authority that tells us that Article 1, Protocol 1 is not engaged in these cases. So that point didn't go to the Supreme Court. So this is the authority for that. So a licence isn't a possession.
Right.
The reason that I mention that, apart from the fact that it goes to the general nature of what it is to have a sponsor licence, is if we go back to page 70, to paragraph 75, at page 716, the court said that although the judge below had looked at the matter in terms of proportionality as well as rationality, I take the view that the proportionality analysis is not necessary.
Yes.
And we rely on that as a statement of principle from this court. And we say, so insofar, for example, in supporting care, as the judge says otherwise, he was wrong to do so.
I'm sorry, which paragraph are you there?
75.
Forgive me, thank you.
Yes, I didn't understand the judge in supporting care at paragraph 55 to found that reference to proportionality in the ECHR.
No.
But that may beg the question, well, where did he get that principle from?
But, I mean, at 75, the court says, we don't think proportionality is involved. It's because A1, P1 is not involved, and also Article 8 isn't. So it seems to presuppose that if no rights are engaged under the Convention, then proportionality doesn't apply. And that would be my submission.
Yeah, well that's another a PhD thesis,
Indeed.
which I think we probably don't need to embark on in this appeal. The Supreme Court has said that they may have to decide one day whether proportionality is a freestanding doctrine of English public law. But that's not the way this has been argued. I understand your submission, A1, P1, irrelevant, and this court said proportionality.
That's the extent of the submission. And then thirdly, in this court, Rajan Knoll, which you were taken to as one, and that's in volume 3. 1081.
1080.
1081. Paragraphs 38 and 39. This is Lord Justice Tomlinson. And the criticism being made by the appellant in this case was that the Secretary of State hadn't properly considered the exercise of her discretion when deciding whether to revoke. And the complaint was that the decision letter contained no analysis of the consequences of revocation for either the appellant or the residents, despite, in that case, those consequences having been specifically raised in the appellant's letter. And it was said that the Secretary of State needed to. And he said, I've already pointed out that the assertions about what would happen were unsubstantiated. So it's perhaps not surprising the respondent felt it unnecessary to address them. But he goes on to say, there's also the point that so far as concerns a failure to comply with subparagraph Annex 5, revocation was in any event mandatory. And revocation where that is engaged is generally to be expected in the absence of exceptional circumstances. And it wasn't necessary for the respondent to spell it out as exceptional circumstances were neither relied upon nor present.
Was the phrase exceptional circumstances in the guidance at that time?
It appears to have been in the version there. So there's a reference to 19.6. I think we can see 19.6. Yeah, so it's at page 1063, my lord. They set out the guidance.
He does that at some length, doesn't he?
He does. And 19.6, it says we can't. It's a bit like the current guidance under the second annex. Yeah. It says we can't define what the exceptional circumstances are, but we'll look at it.
This is a Court of Appeal decision.
It is.
So do you say that this is binding on this court? And therefore, this point has been decided already by this court? Because paragraph 38 seems to be very similar to the complaint that was made in our case.
Yes, my lord. I do say that. I say that that this court has already said there is no need to analyse the consequences for the appellant in terms of its business, for the residents of the care homes, even if, as in this case, they are brought to the attention of the Secretary of State. And certainly if that would apply even more so if not.
And it also appears to deal with a second argument that was being made there. In the first sentence of 38, counsel made the point that the respondent failed to demonstrate that she had properly considered the exercise of her discretion. Now that, of course, is again a freestanding ground of public law.
Yes.
It's well established that if you have a discretion, you have to consider exercising it. You can't close your mind to the possibility of exercising it. But if I understood this decision correctly, that submission was rejected.
Well, at 39, it says it certainly wasn't necessary for the Secretary of State to address them. I mean, I suppose the Secretary of State would have to consider it in order to know it's something it doesn't need to. She doesn't need to address.
Yeah, but I wonder. I don't know. But is it your submission in the present cases? What the Secretary of State did was, even if and to the extent that there is any residual discretion, she's chosen not to exercise it.
Yes.
She said the normal position is mandatory revocation, and I'm mandatorily revoking. It's implicit.
Yes.
You've decided not to exercise your discretion.
Yes, and when I come to submissions on the two individual cases, that's what I will say. So in both the decision letters, Secretary of State says in terms, downgrading is not appropriate, this is too serious. And we say that that is consideration of the circumstances. Obviously, in both cases, it wasn't the case that the Secretary of State had been said, we want you to consider impact or these things. They only came afterwards.
Yes.
But even if they had come, I mean, I think the simple answer that I would give to my lord is the Secretary of State would, as Mr McGee says, look at the letter from Gateshead Council. So they would consider it in the sense they would see, oh, it's a letter from Gateshead Council. But this isn't something we need to address where this is a serious breach and revocation. And when we say that's consistent with what this court has already said in Raj and Knoll.
Does the removal of the exceptional circumstances provision affect that analysis either way?
That's another very good question. Would it, if anything, it narrows the discretion because it's not one that is even indicated in the guidance. So, although I accept there is a residual discretion, it's not one that's there in terms.
Well, forgive me for interrupting you, but if exceptional circumstances is in the guidance, then there's a provision for exercise discretion within the guidance. If it's not there, then and your residual discretion is a public law residual discretion or something extra outside the guidance, to what extent does the analysis in Roger Knoll apply? It may not. Again, I'm conscious that I'm interrupting you, and you might want to come back to that. You may tell me it's irrelevant.
Well, just, if one looks at page 1063, you can see the way that the guidance was at the time. And it appears that at the time, it didn't have quite the same structure.
No.
But at 19.4, if any circumstances Annex 5 arise, we will revoke your licence straight away. 19.6, we can't define in which exceptional circumstances we may not revoke your sponsor licence, but when one of the circumstances listed in Annex 6 applies, so that's more like our Annex 2, we'll look for evidence of this. So what 19.6 seems to permit, which isn't in the current guidance, is the possibility of there being exceptional circumstances generally.
Yes, but looking at the examples, it seems to go to the nature of the breach rather than the impact points.
Yes, it does. Well, I will, if I may, think about that point further.
Thank you.
But what I would say, and the point I was going to make about this, is that even where there was that in the guidance, this is what this court has said, and it can't be the case that with the guidance that we now have, there is a greater requirement on the Secretary of State to consider the exercise of that discretion, and a greater requirement to give reasons for not doing so. Yes. One very brief point, just while I have that case open. Paragraph 16, page 1070. One can see that the representation that was made, which is perhaps has some similarities with the one in Prestwick that they say they would have made. The suspension would be grossly unreasonable. Business is reliant on a number of migrant staff, complex needs of residents, also have a significant impact on the residents, etc. So that's the factual background. But the point that this court took was that At the final sentence, paragraph 16, no evidence was supplied as to the appellant's financial position, or therefore as to its ability to pay its employees at enhanced rates. And in my submission, that is similar to the concerns expressed by Mr. Justice Nichol in the Birds Hill case, that if one is going to make the argument at all, financially this is just not possible. You need much better evidence than just this sort of letter, dated 30th of May. But that's, although I raise it because it was dealt with by His Honour Judge Kramer, and we don't disagree with that, it is quite a long way down the priority of the points that I make, because we say, even if they did, even if they gave you an accountant's report, it's not going to affect the fundamental position in these cases. So, to summarise, I make 4 points about that case. First, they had raised that issue in this case, so unlike these two cases. Secondly, the court nevertheless felt that the point was unsubstantiated. Thirdly, this court held there was no need for the Secretary of State to even address this point, even when it had been specifically raised. And I pause there because, my Lord, that is quite a statement in public law case, that even where someone specifically says something, there's no requirement on the public authority to even address the fact that it's been raised with them. And then fourthly, that this court appeared to consider it was a complete answer that it was a mandatory breach. I was going to go to the New London College case next in the Supreme Court. I think Mr. Southey went to the relevant passages this morning. So can I just, rather than take you to it, just make to the point that I was going to make, is paragraphs 21, 22.
29.
21 and 22.
Thank you.
And this point is in our skeleton, that it's equally mandatory, whether it's in the process for applying for a sponsor licence or in the Part 3 process for revoking a sponsor licence. And it was obvious that Lord Sumption did regard them as mandatory and as rules, hence all the discussion. And then thirdly, it's the point at paragraph 29 of that judgment, which is, again in our skeleton, that he emphasised there are substantial advantages for sponsors in participating in these schemes, but they're not obliged to do so. The rules are there, and they are in reality conditions of participation, and sponsors seeking the advantages of a licence can't complain if they're required to adhere to them. And I'll come back to the point about fairness, but in essence, I read that part of the judgment as saying the rules contain the scheme that you choose or don't choose to participate in, and you can't complain about that. And it is inconsistent with that general approach to say, yes, we want to participate in the scheme, but when it comes to an assessment of whether we've breached the scheme or not, we don't want the rules in this scheme. We want a different approach that, for example, gives us a specific opportunity to offer mitigation about other factors that are not there in the guidance.
But you accept that the procedure has to be a fair one?
Yes.
And I think what you're saying implicitly is that there has been no challenge to the content of the guidance.
Yes.
And therefore, the process which has to be followed is as set out in the guidance. And that is both a rational and a fair process.
Yes, that was That was my argument. Yes, my lord. And it's not the way the case is put this morning, but below, Mr. Southey, you see it in the judgment, you made the argument to the judge that there should be a second stage. That once the Secretary of State's decided on, is there a breach, and well, I'm upholding this breach, there should then be another round of representations. And the judge made the point, well, that's not what is in this scheme. And we would say precisely that the scheme is the standard of fairness.
Yes. And again, we have to be slightly careful not to forget general public law. Generally in public law, you have a statutory context. And so what fairness requires is shaped, at least to some extent, by the statutory context. But here, you would say by analogy, what fairness requires has been shaped by what is set out in the guidance.
Yes.
We don't have an express statutory framework, for reasons we were discussing earlier this afternoon. So that in a sense, the entire framework of rules which govern this procedure, this administrative decision-making procedure, are those set out in the guidance. That wouldn't preclude someone from bringing another judicial review challenge, if they wish to, saying the guidance is unlawful for some reason. They might say the guidance is inherently unfair.
Yes.
They could say that, but they haven't said that. That's not the nature of the challenge. So what you're saying is, well, we followed the process in the guidance, and it was a fair process.
And for example, I think the point I made earlier may be an example of that. Mr. Southey says, well, some of these things in Annex 1, that's fair enough, some of them it's not. But that's inconsistent with an approach to this is the guidance, because if the guidance is lawful, and there is no challenge to the guidance, then it's lawful for the Secretary of State to say these are the things that will be mandatory. And my Lord is right, there could be a challenge to the guidance. Someone could say, well, it's not fair that you have this process, or you don't allow this, or whatever it might be. Well, I was then coming on to the first instance decisions. I'll deal with those as quickly as possible.
As with Mr. Southey, we will hold you to the agreed timetable.
Yes.
How are you doing for time?
I'm a bit behind.
Okay.
But I have half an hour in the morning, and I can, I think, cut my cloth.
All right. Well,
So the first instance decisions, you have a significant number. You have Birds Hill, Datamatics, London, Reading College, New Hope, One Trees, Taste of India, Tender Care, West. You have all of those. To the extent that the court wanted to go beyond things that are in the skeletons, my submission is they speak with one voice as to this process. There are cases where unfairness has been found. Those cases are, I think without exception, cases where the expectation created by the guidance is not followed. So a particular allegation isn't particularised, whatever it might be.
It's New Hope, isn't it? Particularly, was it New Hope?
So there are three cases that post-date Prestwick and Sporting Care: New Hope, One Trees, and Tender Care. I think it's probably New Hope
Is the one where there's a fairness challenge.
Yes.
So it succeeded.
I think it is the one where I believe so, my lord. Yes. Yes, it is. So New Hope is the one where the fairness challenge, but it was because the guidance hadn't been followed. So I wanted to mention a couple of them. First is Birds Hill, because it's relevant in that it's a nursing home, as some of these are, but also one of the residents was a party, was one of the claimants. So the claimants were a resident, and so the issue of the effect on the residents and care was very much to the fore in respect to Mr. Justice Nichols' consideration. And in fact, it was argued in that case that Article 8 meant that revocation was inappropriate. And you were taken to the case this morning.
just give us the reference again.
Yeah, so it's tab 6, which is not going to help. It's volume 1, page 307. and the relevant paragraphs are 15 and 40 and 44. The particular point I think that it adds, that and it's referred to in other cases, is that it's from this case that His Honour Judge Kramer in Prestwick took the point that assumptions about how disastrous things will be are not to be taken lightly by the courts. It's a similar point to the Raj and Knoll point. How often it is that dire predictions prove ill-founded. That the business might be taken over by somebody else.
Which passage where are you?
Paragraph 40, page 315. Mr. Southey is right, this is in the context of an Article 8 discussion, but I'm not sure that assists him. I mean, the level of scrutiny is even greater in an Article 8 case. But anyway, I say that the general point is still a good one.
I'm not sure what is that? Is that a proposition of law? Is that experience of life?
I think the anecdote of Mr. Justice Warby, is that what it is?
The proposition, I'm not sure it is a principle of law, but I think the proposition that I say emerges from this is that the court should not assume that because the operator of a sponsor license asserts in a letter that they will have to close or that there will be disastrous consequences, that should be taken at face value, because that may not be the case.
No, but that might be relevant if the nature of a challenge is, well, you reached a conclusion which is irrational. That's not Mr. Southey's challenge. What he says is that you didn't take this into account and you never gave us the opportunity to say anything about it. And just because I'm not sure where it gets one to say what often dire predictions prove ill-founded once put to if they're never put to the test.
Well, this comes to the, as I say, it's some way down the priority of my submissions.
Yeah, well, that I understand.
But in Prestwick, it arises because what Mr. Southey is able to do in his case is he says, if you had given us the opportunity, this is the evidence we would have provided.
Yeah, and you might not have accepted it, or you might have accepted it but not found it persuasive.
Well, but that evidence is not the sort of evidence that Mr. Justice Nichol thought was necessary. Right. And so it is really, I suppose, only relevant for this court in support of my Section 31 point.
Yes, I see. All
right. The other point about this, though, is that he went on to say, even if that hurdle was surmounted, so even if I accepted this evidence, it was still reasonable to revoke. So again, it's more about rationality, it's not about process, so it probably goes more to supporting care. But there we are.
Okay. That's Bird's Hill.
Datamatics, which is page 343, and it's just one paragraph at 350. I don't need to read it, but this is the case that establishes in this context that where dishonesty is alleged, it's not a question of precedent fact, and a number of other first instance cases adopt that. And again, we say that goes to the nature of the process, because there are contexts where if an allegation of dishonesty is made and it then comes for review, it's looked at as a question of precedent fact. But in this context, it's simply a question of rationality. Was it reasonable? There is no dishonesty issue in Prestwick, there is in supporting care. Yes. So in supporting care, there are two mandatory grounds, one of which effectively turns on it being a deliberate action.
So which passage in Ms. Leaven issue then was judgment? Do you rely on?
It's paragraph 20. The highlighting has dropped away. It's 19 to 20. And the other point, and again, this is again just the first instance indication, that at 353 there was a Tameside challenge that was rejected. And it was rejected on the basis that the process, which is that in the guidance, is reasonable, or she says wholly reasonable, proportionate. So the defendants, 29, the defendant's officers interviewed Mr. Gandhi and a number of the workers, considered documents that were submitted to her, gave them an opportunity to respond to the letter, draw attention to any material it thought relevant, no breach of the Tameside duty here. Obviously not binding on this court, but it's an indication that at least...
Which paragraph are you then reading from? Sorry.
That was 29.
29, sorry.
Gold Care Homes is the third of the older pre-Prestwick cases. It's in volume 3, page 851. Sorry, it's volume 2.
Volume 2, page...
833 begins.
Thank you. Yes, Gold Care, right. And where do you want us to go in that?
I was going to go to 36. This may be unnecessary, but the court will be well aware of this principle, but I thought it was important to mention it in this context. So this is about the requirements of procedural fairness.
Yes.
So this was a case about fairness.
Yes.
And it makes the point that what is required as a matter of procedural fairness, so the content of the duty,
Yes.
depends on the subject matter, etc. Depends on the character of the decision-making body, the kind of decision-making it has to do. And
yeah, that is important, if I may say so. This is really what I was driving at earlier, that one of the factors which shapes what fairness requires is the statutory content, and this is a helpful reminder that it depends on the character of the decision-making body, the kind of decision it has to make, and the statutory or other framework in which it operates.
there isn't a great deal more in terms of analysis to that in the judgment. Just for your notice, at paragraph 79, she gave her conclusion on it. She says there's nothing in the allegations of procedural fairness, and fairness effectively saying the opportunity was given in interviews and on paper. Then I come to the three recent cases, the first of which in volume 2, New Hope. (686). This,
yes.
You were taken to this morning, David Piewski judgment. You were taken to most of it on Mr. Southey, but I just wanted to highlight at the bottom of 686
Yes.
That he regarded Judge Kramer in Prestwick as having identified what he called serious principled and methodological objections, with the notion that the defendant is required to consider the precise impact of revocation on a licence holder or on the care economy. And I just mentioned that he identified them as serious and principled. And then he draws the distinction that you were taken to at 127, saying that the Secretary of State may need to stand back from the particular misconduct and look at whether sanction is proportionate. I'm not sure we accept that, in particular if it's in respect of a mandatory breach. But that is a different point to the sort of point being made in Prestwick. That is a point saying, well, is it proportionate to the circumstances of the breach? But his second distinction, the being required to investigate and make findings about particular impacts on individuals, employees, actual employees, family members of employees, or, and this is the point that we say is important, to try and predict or assess the impact of revocation on the UK care support economy, is not required for the reasons set out in Prestwick. So I think we don't entirely agree with the first part of that, but I mean, to some extent I agree with Mr. Southey that the distinction between those two is not entirely clear, but we certainly adopt what's said in the second part of that. And in that context, the paragraph that follows is notable because clearly what he doesn't have in mind is that things like the impact of the business on its workers and families are things that the Secretary of State needs to address, because he says in terms, next to letter D, the defendant can be taken to have known the size of the business, understood the potential impact. These are, to be blunt, obvious. They are the potential consequences of any decision to revoke a large organisation's sponsor licence. And that we do agree with. And the One Trees Estates case, decision of another deputy judge, Margaret Obi, begins at 818 in the same volume.
Sorry, which page?
It is at page 830.
Yes.
And this case is, it doesn't go as far as the tender care case in talking about that there not being a two-way street. It's perhaps less controversial. But what it does say at 36 is that although the Secretary of State has a residual discretion, I accepted the submission made by Mr. Howarth that in the absence of a particular reason to exercise it, for a reason that's not already factored into or provided for in the guidance, there's no obligation to address or provide reasons for not exercising this residual discretion in individual cases. And my Lord, that was the submission that I was trying to encapsulate in my submission.
Yes.
That I don't know whether that makes it a relevant or an irrelevant consideration, but it's not one that the Secretary of State is required to address.
Well, as I say, subject to further submission, it seems to me that one way through this conundrum may be to recognise that in fact there are three categories, not only two. If one talks simply about relevant and irrelevant considerations, that suggests that there's a rigid dichotomy. But if one conceives of it as mandatory relevant considerations, prohibited considerations, and in the middle, permitted considerations, that may help to resolve some of these problems. Because then you're not required to take them into account, but you wouldn't be acting unlawfully if you did take them into account.
Not required to take them into account, and it would follow, if this is how we define that category, you're not required to ask for representations about it. Yes. In that case,
or start making your own inquiries about them, because claim side doesn't arise because it's not a mandatory relevant consideration. That may be one way of resolving this, but I understand your submission based on the first part of paragraph 36 of this judgment. And from memory, That's not radically different from what the Supreme Court said in Friends of the Earth. But there are some things that you don't need to address expressly. You don't have to say that I've considered that. But you wouldn't be acting unlawfully if you did consider it. That's the point I'm driving at.
Could we just look at it? She accepts that 36 that she accepted Mr. Howarth's submissions for the Secretary of State. Are those the submissions on the previous page, paragraph 29 to 31? I presume they are.
Yes, well, yes, it seems to be paragraph 30 that she's referring back to. He submitted, the Secretary of State is not required to inform himself or address the impact of revocation on the sponsor's business and or wider industry.
We've had a lot of first instance decisions cited to us by both parties. Are these subject to appeal to this court, or are they waiting the outcome of the present appeals?
I can take instruction. I'm not aware of any of those three being. I mean, Mr. Malik may know about one or other of them.
Well, with all of our questions, these are something that we welcome assistance on tomorrow. It doesn't have to be now. I'm very conscious that you've got a limited amount of time to finish your submissions today.
I will take instructions and find out. It is right that there are a number. I mean, this case was effectively called in because of two of them, but there are a number, and there are others, I think, that are pending as well. And just to complete what I said about paragraph 36, over the page, it probably follows, obviously, but we rely on what she says at the end there. So having decided that downgrading as an alternative to revocation would not be appropriate, not required to assess the impact of revocation.
Right.
And that is the process that we say is correct. And then 38 puts it into, I suppose, the parameters of the legal framework, saying that there would be no proper basis for an exercise of residual discretion in favour of the claimant, given that conclusion about the breach of the guidance. And the final one of those cases, I won't take you back to it unless you wish to. It's the tender care case at 1287 through to 1289 in Bundle 3. And you were taken to that in some detail this morning, where the judge talks about mandatory being a rule, and where it is a rule, although there is a residual public law discretion, it's not a two-way street. The only other point I make about all of those first instance decisions is that although, of course, the judge's views should be weighed and not counted, it is, in my submission, significant that if one looks at all of those cases, they speak with one voice. And if His Honour Judge Kramer was wrong in Prestwick, or if His Honour Judge Sadiq was correct in supporting Care, then it would appear that those three judges, certainly post-Prestwick, are also all wrong, because they expressly say.
Well, that's one reason why I think we need to know before the end of the hearing tomorrow which, if any, of these other cases is currently under appeal to this court, because we don't want to say something inadvertently which effectively decides some other appeal which isn't in front of us.
And could be being listed fairly promptly, I suppose.
Anyway, I'd just like to know, I'd like to get a full picture of the likely impact of our judgment.
Of course.
Thank you.
So I now move to the second part of my submissions. So that dealt with the general issue.
Yes.
And just, I suppose, sorry, what I should say is, if I am right in that submission, and certainly insofar as supporting Care is concerned, it is directly contrary to what paragraph 55 says. And so I will say something more about supporting Care, but a lot of it is within those.
Right.
So coming back to Prestwick and responding to the submissions this morning, just dealing with the facts first there are three brief points on the facts. The first is that, as a matter of fact, these issues about impact were not raised before the decision was taken. And it's important to be clear about, Mr. Southey correctly says, for example, the email from Gateshead was before the judge. The second statement of Ms. Cora was before the judge, but it was not before the Secretary of State that the decision was taken. Not only were the matters not raised, but they did not ask for more time to make representations. They put in detailed representations that you were taken to. They're in the supplemental bundle, page 177 of the supplemental bundle in Prestwick. You can see at the end of that what they choose to say is that, based on everything set out above, which dealt with points about a number of, but not all of the breaches, where we've fallen short of our obligations, we have identified how we're addressing the breaches and have explained these in detail below. And if you require any further information, please don't hesitate to contact us. And that's all that it said when addressing the specific points. So their case is that, notwithstanding that they didn't even mention the impact of revocation, that the Secretary of State was obliged to go away and consider it. I'll come back to the Thames side. The second factual point is that in Prestwick there were multiple grounds for revocation. In our skeleton argument, I've given a summary. I think it's on the third page, with a table. So in effect, you have 7 grounds, 2 of which were mandatory. The first one was that incorrect job descriptions were there, and I repeat the point I made earlier, that there were, although there may be hundreds of employees, there were 29 who were interviewed, and 5 of those had incorrect job descriptions. And as Mr. Southey said, although in fact the response refused to accept that, Ms. Cora's second statement, which His Honour Judge should make clear, His Honour Judge Kramer refused to very carefully decided that he was not going to consider it. So it's a matter for this court whether to consider it. Mr. Southey has referred to it. She accepted that they were not working in accordance with their job descriptions. So 5 out of the 29. The second mandatory ground was that 2 of the workers, again out of the 29, did not understand what the deductions for the salary sacrifice were. Therefore, they weren't being paid in line with their certificate of sponsorship. There were also a number of grounds that would lead to the licence being normally revoked, absent exceptional circumstances. And those are not on, well, those are by definition issues that are not insignificant. So staff being told they wouldn't receive sick pay, recoupment of a charge the sponsor paid to the Secretary of State, the recouped cost issues. This is recoupment of costs incurred, including replacement of the contract that had been agreed with the workers before they travelled to the UK, with a replacement contract when they arrived with different terms, and 2 breaches that were not significantly disputed in terms of monitoring immigration status, failing to have a process to monitor the visa expiry dates, and secondly, failing to have an effective system to meet their record-keeping duties. Now, a number of those were quite robustly challenged before His Honour Judge Kramer. It's quite a long hearing, but he upheld the Secretary of State's entitlement to find that all of those had been breached. So the reason for mentioning that is that it gives a sense of the scale of the breaches in Prestwick's case. And the third point on the facts in Prestwick is that the only complaint in the judicial review claim was on procedural grounds. Quite deliberately, as I understand it, there was no suggestion that it was irrational or any of the other public law avenues that Michael Lord has mentioned, solely on the basis that it was unfair. The general argument made under ground 1 by Mr. Southey is that the Secretary of State has a legal obligation to take into account the effect on care of revoking licences in the case of someone like with a large number of people, of residents and patients. It is, in my submission, a remarkable submission. It requires the Secretary of State for the Home Department to understand the effect on the healthcare sector, to consider the impact, presumably, of every decision that's taken in these cases on the local and national scale. There are a number of points that His Honour Judge Kramer makes in the judgment. We agree with all of those in terms of the difficulty for the Secretary of State, if this was indeed something the Secretary of State is required to assess in these cases. We note that in the skeleton argument for Prestwick, they say, for example, that the size of a care home is a factor. So the Secretary of State needs to judge how big is this care home in terms of what the impact's going to be. They would presume, although it's not in their written argument, or said this morning, but logically, they would presumably say that the proportion of workers who are sponsored workers is a factor too. I mean, and it was said this morning that it was particularly important that the sponsored workers tended to be in senior positions. And one point I would make about that is that that would mean that the more dependent the care home has chosen to be on its overseas workers, the more leniently they should be treated by the Secretary of State.
Not necessarily. I think it's important to bear in mind the fundamentals of the appellant's argument. I'm not saying the Secretary of State is compelled by law to reach a particular outcome which is favourable to them. They're not saying that. That would be an irrationality challenge. But what Mr. Southey does say is, leave aside his procedural fairness argument, to which you will return, he says that the Secretary of State is required, as a matter of law, to take into account the impact of the decision. For example, on the performance by local authorities of their statutory obligations. And that and he also submits that that's the whole point in this immigration context. You wouldn't have this scheme if you didn't need workers from overseas because you were able to recruit adequately from within the domestic labour market. And so simply to say that it's just irrelevant, he doesn't accept that as a matter of law. And he points to the fact that it's not just a matter of a good idea, but that the Parliament has thought fit to impose certain duties on public authorities. Now, if having taken all of that into account, you still came to the same outcome, he might have great difficulty in challenging that. But what he's challenging is, what he says, was a failure to take it into account.
Which I think leads me to the next point I was going to make, which is where does that duty come from? He says that there are duties on the NHS, for example, to provide this care, and the Secretary of State needs to, because of those duties, the Secretary of State needs to take that into account when making her decisions about immigration. We don't accept that as a legal principle, and I'm not sure, having heard the submissions this morning, where the legal principle is said to come from. Because in the written case, it was put on the basis of one search, also the way it was put below, as derived from Hadfield. Now, Hadfield, so the Padfield principle, public authorities must use their statutory powers to promote the goals of the statute that gave them those powers. Normally, the complaint, or perhaps most commonly, the complaint in a Padfield case is that the relevant public authority is using their powers for a purpose that is outside or beyond the purpose for which they were given. And I did include, I don't need to ask you to turn this out, but I included in the case I sent yesterday the Palestinian Solidarity Campaign case in the Supreme Court,
Yes.
where in a split decision the court looked at the Padfield principle and came to a very what's the most appropriate word? I was going to say extreme. It's probably the wrong word, but it's certainly towards
Robust?
more extreme, robust. Thank you, my lord. A very robust decision as to how narrow it should be, rejecting the argument that the relevant Secretary of State in that case could use powers for other objectives. This paragraph in particular, 41, I think. So, accepting the submissions from Mr. Giffen, the claimants, what the Secretary of State sought to do in the guidance was to promote the government's own political approach by asking the authorities to refrain from making particular investments. And it was outside the very specific, this pensions case, very specific power that it was intended to be used for. So public authorities do have to be careful in terms of exercising their statutory powers for anything beyond the purpose of those statutory powers. Now, I'm not saying that it would be unlawful for the Home Secretary to have regard to the impact in terms of statutory power, not least because, as I understand it, it's not a statutory power. But it's not an obvious application of the Padfield principle. And the one search principle is a principle that not only do you have to act within the purpose of your own powers, but you have to not prevent other powers being exercised. And Mr. Southey accepted, I think, on the basis of the Islington decision, that he couldn't make the argument in the way that it was in the skeleton because of the threshold for such an argument. And I would ask you just to turn that up.
Yes.
That's the case. You also have the Somerset decision in the bundle, but on rereading it seems to me that this decision, which comes after, is the clearer.
Right.
So paragraph 111, towards the end of the judgment.
Yes.
Right, now you have to have just...
It's a schools case.
Yes.
And
whereabouts in the bundle?
This is the
It's not. It's in the additional cases that I have here.
one of the three you've got
Yep,
this morning.
sorry. Thank you.
So the one search principle at 111 says was considered in the Somerset case that you do have.
Yes.
This case sets out the high hurdle that would have to be cleared for the Commissioner to fail this test. Must be shown that by making the order, the Commissioner and Secretary of State had, quote, utterly defeated the Council's target duties to provide education. And paragraph 112, Council acknowledged the difficulty, but 113, rejected by Mr. Justice Chowdhury, says, attractively though the submission was made, I'm unable to accept it. It might be said the decision not to revoke the Academy order makes it more difficult for the Council to achieve its statutory objectives. The fact the school will not close may mean the Council will have to consider other alternatives, which may or may not involve closure of another school. But that's a far cry from establishing that the Council's ability to achieve those objectives has been, quote, utterly defeated. Educational provision in the borough might look slightly different when the school is taken out of the Council's control, but may nevertheless be considered efficient and conducive to the promotion of high standards. And in my submission, it doesn't get off the ground to say that even if one takes at face value the email from Gateshead, for example, that the statutory powers, which are still not identified specifically by the claimant, but some powers under the Care Act are utterly defeated. So we say that the legal principle on which he relies doesn't get into point that he needs. Then the alternative basis for it was the ECPAT case that he relied on this morning. ECPAT was obviously a very different sort of case. As he said, it was about unaccompanied children in hotels. But he relied on sorry, I do need to ask you to turn to ECPAT as well, which is at...
Where's that?
404 is the page, which is, I think, at the end of volume 1.
Right. Yes, I think particularly paragraph 206 on page 406.
Yes, sorry, it is 406. Yes. And the short point I want to make about this is that he said this morning that sentence at the end, but remedying a breach of duty by one public authority may often require action by another, particularly where the remedy may involve the provision of additional funding, was the principle on which he relies.
Yes.
In this case, he says, the only foundation he can find for that principle. In my submission, that is not a principle at all. One has to have a look at the judgment to see where that comes in context. So this was about issues, that paragraph related to the lawfulness of the Secretary of State's use of hotels to accommodate unaccompanied asylum-seeking children. And we see that from 186 onwards. So that section begins, 186, party submissions reflect their very different perspectives about how to characterise the Secretary's use of hotels. And the heading is, so that's the issue there. And so it's whether it was lawful for those children to be accommodated by the Secretary of State in hotels, and he also then comes on to at what point it became unlawful, and whether the Secretary of State, by doing so, had frustrated the statutory purpose of the Immigration Act. But the paragraph itself was not about the Secretary of State for the Home Department specifically. It was about the power of government generally. The point in that, it appears to be just in the context of a discussion in deciding whether or not it was lawful for the Secretary of State to be accommodating these children in hotels. And the heading under 5, the fifth part of this, is what can the government do? So sort of saying, having said, well, it was unlawful, or it became unlawful at a particular point for the Secretary of State to still be accommodating these children in hotels, effectively just making including a passage in the judgment to indicate that this doesn't mean it's all hopeless. So what can the government do? It's not a legal principle. It's just saying that it may be that another public authority has to take action when one can't, so where the councils can't in this case, someone else may need to. I don't read that as saying that there's any particular principle. Still less that there's a clear principle which can be read across to a case like this. The next point that I think was made by the appellant is that the argument is that the Secretary of State, in the decision letter in Prestwick, appeared to accept that account should be taken of impact, because of the phrasing that's used in the letter to say that we always consider.
Yes.
So if we just look at that. I've lost the.
This is at the back of the core bundle.
Thank you, Laura.
Page 316.
316 to 317, yes. We always, paragraph 95, we always take into consideration the potential impact revocation may have on a sponsor. Consideration is always given to re-rating a sponsor.
Yes.
We've considered the possibility of downgrading your licence, issuing an action plan. We'll only do so if there's scope to rectify shortcomings or omissions in systems or retained documents. But then goes on to say, but in this case, these are the serious breaches that you've committed. Downgrading your licence is not appropriate due to the seriousness of your non-compliance with your sponsor duties. So they say, well, we will take into account the potential impact, but in this case, it doesn't matter because these are so serious, it's not appropriate. Well, that is exactly the set that we say it's exactly consistent with the way that Judge Margaret Obi explained it in the One Trees Estates case, that the Secretary of State is entitled to say, well, we'll listen to anything you've got to say, but if this is sufficiently serious, and the annexes tell us which ones are, then downgrading is not appropriate.
That's why I thought your argument was, because of paragraph 95, that we do not regard the potential impact of revocation as being irrelevant in the sense of being a prohibited consideration. But we do take it into account. We have taken it into account, and this is the decision that we come to. You know, I thought that was the structure of the decision.
It is. I mean,
But what supporting care has gone on to hold is that you're under an obligation to go further.
yes.
And to consider, for example, the potential impact on residents, presumably, on possibly, or Mr. Southey would say.
And they say residents, other employees.
Exactly, and local authorities.
And the care sector generally.
Exactly, yeah. And that may or may not be a good argument, but even if that argument is a bad argument, I thought you were accepting in paragraph 95, and I think you are still accepting, that it's not that these things are prohibited, that we have to exclude them from our minds. They are permitted. We can take them into account, and we did.
Well, I am going to give further thought to the prohibited, permitted division. But they're not prohibited in the sense that the Secretary of State can't consider. The Secretary of State, of course, needs to consider any representation that's made. But they're not matters, if they're of this type, which the Secretary of State needs to address.
95 and 96 are focused very much on the impact on the sponsor.
Yes.
And the steps that can be taken, downgrading as opposed to revoking. It doesn't refer to other impacts.
It doesn't. In terms, it just says in terms of the potential impact on a sponsor. What you do have, though, I appreciate it came after the decision, but you have a statement from the decision maker, Mr. McGee, and at page 250, paragraph 27 onwards, he says in terms, we are aware of the impact that a sponsor licence can have.
That's a different point, though, isn't it, really, from what's being said at 95. We always take into consideration the impact on the sponsor, may have on the sponsor.
But, again, at the risk of repeating myself, I adopt what was said in the case law in terms of it being obvious in these cases that there will be an impact on the workers, on the care home, and on residents in the event that
if you're dealing with the normally revoke
yes
obligations, if I can use that phrase, you know what
a C2.
Yeah, as opposed to mandatory. Are those circumstances in which the impact on the sponsor would be more pertinent or more likely to have an impact, or they would be more likely to have an impact, potential impact on your decision. I mean, this covers ground you've already covered, Mr. Mangle, so I don't want to drag you back. It's the number. It will be the nature of the obligations that were broken, the number of breaches, and the circumstances. Yeah.
I was looking at because the guidance does give some assistance on how you exercise that discretion.
Okay. Well then, maybe something else you want to come back to.
Well, it's at 79.
Okay.
The key features seem to be that they look for evidence, you have adequate processes and procedures in place and have taken all reasonable steps. 79 of the supplemental bundle in Prestwick. C10.
C10. Oh, sorry.
10.6. But my lord, the thrust of 10.6 is to say we're not going to tell you what might be exceptional, i.e. we will accept whatever submission you want to make to us on this.
Right.
Would this be a good moment, Mr. Magnol, just to take stock of how you're doing for time? Because we're conscious that you've got to deal with the procedural fairness argument.
Yes. I am a little bit behind, but it's not. I don't think it's catastrophic. So can I move to ground 2 and the tame side?
Yes.
Point. And look, these points, having dealt with the rather lengthy introductory section, these points are now, I think, largely a matter of emphasising points in our skeleton. So in respect of tame side, we do rely on what we say at 39 through to 59 of our skeleton argument. The principles, the Plantagenet principles, obviously agreed by this court, are not in dispute. There are two that I emphasise. The third of those, the first being the third principle, namely that the court should not intervene merely because it considers that further inquiries would have been sensible or desirable. It should only intervene only if no reasonable authority could have been satisfied on the basis of the inquiries made that it possessed the information necessary for its decision. Just pausing there, obviously, it's essential in looking at that to consider the context. So if this is a case which this court indicated in Rajan Null, the discretion isn't going to be exercised for these sorts of reasons, why would the Secretary of State have to go actively looking for things that she wouldn't even need to address had they been brought to her attention? And then the fourth principle, a corollary of that the court should only strike down a decision on this basis if no reasonable decision maker possessed of the material they did have could suppose that the inquiries they had made were sufficient. So it's to be looked at from the perspective of the Secretary of State. So as I've submitted and taken you to the recent case law, although the Secretary of State does have a residual discretion, in the absence of a particular reason to exercise it that isn't already factored into or provided in the guidance, and there's no reason to address it or provide reasons, it can't be incumbent on the Secretary of State to go out and investigate it. We also make the point on tame side that, I think this is accepted, if ground 1 fails, the tame side point must fail as well, because it's an extension of the point. If there's no obligation on the Secretary of State to address points about impact, then there can't be an obligation on the Secretary of State to investigate impact for herself. And we rely in particular on New Hope, One Trees and Tender Care being unanimous in that respect. We adopt what His Honour Judge Kramer said in Prestwick. We say he was right about this. And it's paragraph 90, his judgment. We say that it's in our skeleton, we can't improve on the way that he puts it. Again, we come back to some of the points I made at the beginning. Looking at the St Andrews principles, so those 12 principles, the light trigger, the cynical view, the ability to revoke a license because of suspicion, all of those things, we say it's inconsistent with that light trigger, that light touch response, to have an obligation on the Secretary of State beyond what's in the guidance to go out and investigate the impact of a revocation decision. We say it's contrary to those principles set out in St Andrews and Raj and Knoll. One of the bases of the criticism of Tameside is that it's effectively said, well, you're doing this illogically because you take into account, you say at paragraph 95, you take into account the impact of revocation, but you didn't ask us for evidence about revocation, and you didn't go and make your own inquiries about revocation. But the answer to that is what Mr. McGee says, which is, well, yes, we take it into account, but we don't take it into account by not revoking because the impact might be serious. The way we deal with impact is that we mitigate it by dealing with the Department for Health and Social Care. What we look at is this a sufficiently serious breach that we can't have trust in the sponsor? So we say that you can't get from paragraph 95 to create an obligation on the Secretary of State to go out and investigate. Ground 3 is the heightened standard of fairness point, and we cover that again, I think, quite comprehensively in our skeleton argument at 47 through to 59. Just, it's probably clear, but for the avoidance of doubt, at least in Prestwick, the way that this arises is quite limited. So the standard of fairness, the point is only being made in respect of the impact issue. So it's not a point, obviously at the first instance there was a lot of argument about how fair the rest of the process was, but in this appeal the issue is only, was it fair in the way that the Secretary of State dealt with the issue of impact, effectively by not asking for it. And that seems to be the essence of the complaint. Having heard the submissions this morning, I think, in addition to what's in our skeleton, I would agree with my Lord or Justice Singh that whether there's a heightened standard of fairness doesn't particularly assist. The question here is quite specific. The question is whether the Secretary of State was obliged to ask the appellant for evidence of impact, or ask them at least if there's anything they wanted to say about impact. The judge, firstly, as I say in the skeleton, we agree with what the judge said, paragraphs 27 to 37 of his judgment. He went through the authorities in respect of a heightened standard of fairness. In terms of what he says about that, we say that's right. We say that these cases, particularly Operation Holdings, were about the process as well as the outcome. And we say the same about St Andrews, as I said earlier. But I'll come back to those as well, in fact. I'm just wondering if I can shorten some of this. I'm going to, this is perhaps, I may need to come back to some points, but in respect of the fairness of that specific point, just I suppose to give my headline submission on that, we don't take any issue with the principle in terms of requiring notice of points, and that fairness requires what you need to address, etc. But we do make points both in principle and on the facts. On the facts, we do rely on what's said in the guidance. The claimant, the appellant, is required to know what's in the guidance. The guidance at 9.11 is clear in our submission. It says in terms, page 76, I took you to it earlier, this is your opportunity to seek a review of our decision and set out any mitigating arguments you believe exist. And the suggestion that would not be sufficiently clear, we don't accept. Similarly, the letter itself, perhaps I could just ask you to turn to this. So it's page 159 and 160. So this is the suspension letter in the supplemental bundle. Paragraph 52, we've suspended your licence with immediate effect. You have 20 working days to make representations, including submitting evidence in response to this letter. If you do choose to submit representations, as well as responding to the points above, you must provide the following supporting documents. And as my Lord Justice Singh observed in argument, there is nothing there to say that the sponsor cannot provide other submissions or representations. It is entirely a matter for them. I
did wonder, if you don't mind my interrupting, I wondered if, although we shouldn't construe this as if it were a statute or a contract, nevertheless, I think you might be entitled to point to the words as well as. In paragraph 52, line 5, it says, as well as responding to the points above.
Yeah, I suspect what Mr. Southey would say in response to that is that that's followed with.
Well, you must provide.
Must provide the following documents.
Yeah, no, I understand that.
There's no comma after above.
No. But certainly, yes. I would agree, and my point is looking at that paragraph. It is your submission should include these things. So it should include these documents. Yes. It should include a response to matters above. It's not saying we're not going to look at anything else. And if you look at paragraph 58 over the page, we kindly request that wherever possible, any representations that you make are submitted electronically.
But in any event, your fundamental submission is that the decision letter cannot be read in isolation.
Yes.
It has to be read with the guidance, and you say the guidance should not be read narrowly or restrictively, and basically if there's anything they wish to say, they can. And
I mean, on that, I would go further, that even if that paragraph at C9.11 wasn't there in the guidance, it would still be fair, because they still have the opportunity to put in submissions. It's interesting that there are, in this case, of course, both C1 and C2 breaches. The C2 breaches, as I took you to mentioned in answer to my lord, that there is some indication in the guidance what might be exceptional circumstances, which is we can't define what it is. So clearly, if they wanted to address the C2 breaches, they could put in whatever they like because it says in the guidance. His argument, I think, depends on Prestwick having decided, oh, well, we're faced with mandatory breaches. There's nothing we can say, so we're not going to put anything in. It's, in my submission, that is not a fair submission, and it doesn't reflect a process which allows them to put in, whether or not it was in the guidance, any submission they wish to make. But the fact that C9.11 is clear assists me. We do make the point that they had 20 working days, but the guidance says you can have more time, or there may be, you can ask for more time, and we'll consider it. There was no request for more time, and in fact, they put their response in early. And we, again, rely on what His Honour Judge Kramer says, particularly at 35 and 36. So he rejected the argument, as I've mentioned, on the second step, to find out what the breaches are, and then there should be a... And he says, well, no, that's not consistent with the guidance. And at 36, my Lord, just...
Sorry, 36 of what?
This is His Honour Judge Kramer.
Oh, sorry.
140.
Just to highlight his point about section C9.11, he says it's clear from the guidance that in response to a suspension letter, the responsor can respond in writing. It's also clear from this part of the guidance that the purpose of the response is to seek review of the decision and set out any mitigating arguments. He clearly accepted the submission that the Secretary of State made about the guidance. We say he was right to do so.
Are you going to make submissions about the objective, subjective understanding point? We were shown a judgment about that.
We were the SIAC judgment.
Yes.
I have given it some thought. It's not a point that was stated before this morning. The difficulty with that is that if it's subjective in any sense, so if it depends on what the individual even reasonably understood, rather than what it is objectively, then that cuts across a system of guidance which is supposed to be self-contained. But I'm not. I think the first submission, I will think about that overnight if I may. But the first submission I was going to make on that is that it doesn't appear to take us very far in this case, because we say that there is a clear meaning of paragraph C9.11, that this is your opportunity to set out any mitigating arguments you believe exist. And the only reasonable interpretation of that is one that requires them to set out any mitigating arguments that they believe exist. And the Prestwick could not reasonably look at that paragraph and consider that they were not entitled to put in mitigation in the broad sense.
Thank you.
They did, of course, do so, but afterwards. So they obviously decided at some point that they were able to do so. Can I go back? Oh no, I probably can't go back because of the time. I was going to just highlight some authorities on the heightened standard of fairness point, but I think that's probably going to take me more than 5 minutes. But my submissions on supporting care, I think, are quite short, because I've largely made them in the initial part of my submissions.
Yes, if you're about to move on to a new topic, may I suggest that would be a convenient moment to adjourn. And we note, according to the agreed timetable, you have another half hour to go.
Yes.
Which I think will be adequate for you to make your remaining submissions.
It should be, yes.
Very good. We look forward to hearing you again at 10:30 tomorrow.
Cool, right.